Hello and welcome to your daily dose of Satoshi's news. Today's date is Friday, the 15th of March 2024, the year of 1 million transactions per second or more. Take custody of your digital assets today at rockwallet.com. Right, let's get into it. So let's start off with a little bit of 365 days of Bitcoin history. Where are we today? We've got a lot to get through. Check this out, been adding to this as we go along. Yeah, we've done that one. Let me think, I think we got to, might have been 12th of March. Yeah, there we go, that was the last one. So it was when the last one I did was Greg Maxwell hacking into Satoshi's email. Goodness me, back in 2014, my goodness me. And then on the 12th of March 2024, there was COPA Day 20, closing oral arguments by COPA's Bird and Bird. So check this out. This is what happened on the 12th of March 2024. Judge Miller actually asked Jonathan Hoff, the counsel for COPA, in the documents that he was relying on for his closing arguments, he said to him, are these documents in the bundle on Opus 2 compliant with CPR rule, which is Court Procedure Rules 31.5? And Jonathan Hoff actually replied, no. I mean, this is absolutely outrageous. Absolutely outrageous. I mean, can you imagine going to the High Court and the judge saying, look, are these documents within court procedure rules? No. So they can't be relied upon. I mean, that should be an absolute slap in the face to not be compliant with these court procedure rules. So let's just have a look at this. So this is all about disclosure, 35.1. Number 1, in all claims to which Rule 31.52 does not apply, A, an order to give disclosure is an order to give standard disclosure unless the court directs otherwise. So disclosure is disclosing them to the court, so the court and all the other parties are aware of them. B, the court may dispense with or limit standard disclosure. And C, the parties may agree in writing to dispense with or limit standard disclosure. 2, unless the court otherwise orders paragraphs 3 to 8 apply to a multi-track claims other than those which include a claim for personal injuries. 3, not less than 14 days before the first case management conference, each party must file and serve a report verified by statement of truth, which A, describes briefly what documents exist or may exist that are or may be relevant to the matters in issue in the case. B, describe where and with whom those documents are or may be located. C, in the case of electronic documents, describe how those documents are stored. D, estimates the broad range of costs that could be involved in giving standard disclosure in the case, including the costs for searching for and disclosing the electronically stored documents. And E, states with the direction under paragraph 7 or 8 to be sought. It goes on. But when he asked them, are they compliant? And Jonathan Hoff said no. The judge said, you should read them. Like literally instructing him, you should read them. As in kind of like patronising, how dare you come to court? I would say that almost amounts to contempt of court. Literally relying on documents that have not been disclosed. Honestly, what an absolute joke. It basically means their entire statement should have been disregarded. Like, honestly, absolutely outrageous, telling them that you should read them. So let's have a look at this. This is what Ryushi had said here. So this explains it. A COPA versus Wright, Judge Miller is saying that COPA is lying and wasting court time. They haven't got the documents they said they had. They are violating CPR Rule 31.5. Judge Miller, he literally said, are the documents in bundle in Opus 2 compliant with the CPR rules 31.5? Hoff, no. COPA spent the whole day talking about documents not disclosed. In other words, they are making false claims on Craig using these non-disclosed documents. COPA is violating CPR rule 31.5, and then we've just gone through it. So in English law, you can say whatever you like, simply required to list the documents they rely upon with a statement of truth, unless the other side makes a request for documents. Civil procedure rules, well, that might be what CPR stands for. Disclosure and inspection of documents. Under CPR Rule 31.2, a party who fails to disclose or permit inspection of document may not rely on the document without the court's permission to do so. Honestly, I mean, it's absolutely outrageous. I mean, the only reason I'm saying this is because it sounded very much to me like literally the judge just literally made a ruling instantly without even taking into consideration the closing oral argument, saying the evidence was overwhelming, that CSW was not Satoshi Nakamoto, didn't create Bitcoin, isn't the creator of the Bitcoin network, blah 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 blah. But how can he make that judgment when literally the entire closing argument of COPA's side should have been disregarded? Absolutely outrageous. Dear oh dear. Anyway, so next on the 13th of March, just 2 days ago, 2020, the BTC 2020 bull run started. I've got the point here of the bull run back in 2020. I mean, look at that. March 13th, and again, what I've done is I've outlined the correlation with the rise in BTC with the pumping of Tether into the market. I mean, look at that. Is it as if that doesn't correlate? Because remember, the price is set via supply and demand. So supply and demand can literally be inflated or deflated, by the purchase mechanism, which is Tether, the medium of exchange, being used to buy it. So the medium of exchange is what can be used to manipulate the market. So you can see Tether going up, the price of BTC absolutely soaring, then it coming down again, and then it going up to an all-time high. Honestly, what we're looking at here is absolutely outrageous. And remember, Tether has never been audited. The only thing they can produce is an attestation. And when they were being audited, they complained that the auditor was asking for too much information. Honestly, when you understand what's going on in the space, it's just absolutely hilarious. I mean, all you can do is laugh at the sheer unlawfulness, criminality and skullduggery that's going on, and utter fraud in the space. All predicated upon people just, the powers that be who are doing this, distracting people away from Bitcoin. That's all it is. On the 13th of March 2023, there was a $4.5 billion hack. English Court of Appeal decides on duties of crypto developers. Let's have a quick look at this then. So this was it. An article by Matheson, date 13th of March 2023. So let's have a look at this. So in a significant case for investors in and developers of cryptocurrencies and other blockchain assets, the English Court of Appeal delivered a judgment in Tulip Trading versus Vladimir van der Laan and Oars. The court overturned an earlier High Court decision, also known as the Tulip Trading versus Bitcoin Association case, which held that developers do not owe fiduciary duties to end users. The Court of Appeal held that such duties may in fact be owed. I mean, absolutely. You're developers of the networking system. You absolutely owe a duty of care to the users of the system. Particularly in the case of BTC, where the signatures have been segregated from the transaction data, meaning that accountability is moved from the users of the network onto the developers. Because it's the developers that remove the signatures, which removed accountability. So now they completely control the network. I mean, it's made BTC a security offering. Again, but that's another point we'll have to go into. So round one, High Court, what was the claim for? The plaintiff company, Tulip Trading Limited, alleged that it suffered a significant loss following a hack carried out against Tulip Trust Trading owners, which resulted in Tulip Trading becoming unable to access $4.5 billion, that's a lot more than that now, $4.5 billion in cryptocurrency. Again, it was Bitcoin, not cryptocurrency, but, hey-ho. TTL issued proceedings against the defendant developers, alleging a breach of fiduciary duties and tortious duties on the part of the developers. Tulip Trading Limited also saw an order compelling the developers to change the code base for the cryptocurrencies in question, to negate the alleged fraudulent transaction and return the $4.5 billion to Tulip Trust Limited's wallet. So we'll go on again. I mean, that's really important. So a significant date in Bitcoin history. On the going back to the present, on the 13th of March 2024, COPA, in their closing statement, admitted there were no allegations of forgery or fraud made about Dr. Wright. And effectively what they were doing was only putting their questions about forgery and fraud to him, not alleging them. I mean, this is outrageous because their entire case was predicated upon Craig forging documents, and committing fraud. And in their written closing statements, they actually admitted there were no allegations of forgery or fraud. Like, honestly. So if there are no allegations of forgery or fraud, what are they saying? What is their case predicated upon? What it's predicated upon Patrick Madden's testimony that and statement that literally was destroyed for not being an independent expert opinion. So it says here, again I've written here, Lord Grabbanner stated that the expert opinion of Patrick Madden should not be relied upon since it was found to not be independent, since it was written by the opposing counsel and was not independent at all, and his expertise were also not suitable for the case. So, honestly, I don't... If the judge did make a ruling, literally without even taking into consideration the closing arguments and the case law that Lord Grabbanner put to him, it's outrageous what's gone on. Absolutely outrageous. But we'll come to that in just a minute. On the 14th of March, so this was yesterday, the anniversary of yesterday, 2014, Warren Buffett tells CNBC why he thinks Bitcoins don't have any intrinsic value and investors should stay away. Quite an interesting video, this one. We won't go through it, but really good one. Buffett says Bitcoin is a mirage. Warren Buffett tells CNBC why he thinks Bitcoins don't have any intrinsic value and investors should stay away. Quite an interesting video, worth watching, so click the link. Also, so on the 14th of March 2024, so this was just yesterday, after closing statements have been concluded, Sir Edward James Miller passed judgment in the COPA case and said, I've reached the conclusion that the evidence is overwhelming. And he continued, Dr. Wright is not the author of the Bitcoin white paper. Dr. Wright is not the person who adopted or operated under the pseudonym Satoshi Nakamoto. Dr. Wright is not the person who created the Bitcoin software system. And Dr. Wright is not the author of the Bitcoin software. And this was literally, in the statement that he made. Again, I mean, there seems to be some confusion as to whether or not he was actually judging them or whether he was actually made the ruling and is therefore going to justify them, in his, justify his decisions later in his paperwork. I don't know, but, superfluous to requirements now, if you ask me. And again, 14th of March 2024, the Guardian released an article saying Australian computer scientist is not Bitcoin creator Satoshi Nakamoto. High Court rules. Judge says evidence for his conclusion that Craig Wright did not create Bitcoin is overwhelming. So let's have a look at that. There we go. So that's in the Guardian newspaper. But the thing is, like, Craig has already won, again, been granted copyright of the Bitcoin white paper by a High Court judge. So he's genuinely got the copyright of it, which he's registered and he's entitled to. And he also won the Ira Kleiman case, where nobody else has come forward. And the only person who did have a potential claim on the Satoshi coins was Dave Kleiman. And so his stepbrother Ira Kleiman was trying to get after them. And trial by jury, which stands above all else, said that Craig was the sole and rightful owner of the Satoshi coins, that he mined them on his own. So they're the Satoshi coins. So this ruling is completely contradictory to everything else that's happened. It's absolutely nuts. But we'll go through that in a minute. And today, on the 15th of March 2015, the movie Deep Web was released. The untold story of Bitcoin and the Silk Road. Directed and written by Alex Winter. If you haven't seen it, I'd well recommend it. Absolutely phenomenal a movie. And again, I remember sort of watching this when I was first, trying to figure out what Bitcoin was, and I was just in awe of everything. I was going like, what is this thing? What is going on? I wasn't really awake to the whole, one world government conspiracy just then. Although I knew that the banking sector was completely corrupt because they're nobody else can counterfeit. If an accountant makes value up in the accounts, it's called cooking the books. If anybody else makes money from nothing, it's called counterfeiting. But it's okay for the banks to do it. I mean, it's absolutely outrageous when you really know what's going on. So anyway, let's have a look at one of my posts here. So people have been asking me about, what's going on. So I've said this. Bitcoin is an economic model. The court case is purely for CSW's own safety, because when the market flips due to Terranode or CSW moving a coin, the flippening is justified because CSW is Satoshi, and the fraudsters are those that are calling him a fraud. And eventually the market will flip. It has to, because there is no other way for it to scale. Again, because we know that Adam Back has created the Lightning Network that starves the miners of their block fee. So the block reward just goes down and down and down. It's just those criminals that have got billions of dollars in BTC that might lose it all will look for someone to blame, and now the fingers will point directly at CSW for doing it, since he, quote it, is not Satoshi. So that's the crux of the matter here, really. So, I mean, yes, talk about that a little bit more. So, again, what kind of pissed me off, really, was, again, I've been trying to get this education out. So, COPA, in their closing arguments, tried to justify the existence for BTC due to its market price. I mean, the market price is completely misguided. One of the questions they should have put to Adam Back is, because he's responsible, because he's the CEO of Blockstream that have supposedly scaled Bitcoin, but they haven't scaled Bitcoin. They've created a second layer that is nothing to do with Bitcoin. It's a security offering because there are tokens on it that are meant to represent BTC. So therefore, they're tokens. That actually represent nothing because they don't do anything. They are unregistered illegal security offerings, is what they've created. But the main thing what they've done is to justify this second layer is implemented SegWit and kept the block size to 1 megabyte. And so by literally segregating the digital signatures from the transaction data, you are tampering with digital signatures. That is fraud, straight up fraud. So one of the questions they should have said to Adam Back, you've scaled Bitcoin, have you? You've created the Lightning Network. Can you explain SegWit? So SegWit segregates the digital signatures from the transaction data. So you're tampering with signatures. You're doing something to them, without the permission of those who have made the transactions, who the transactions belong to, because their signature is on it. You are removing the transactions. So you're saying that the only way you could scale Bitcoin is by committing fraud. That is the entire point. Craig is scaling Bitcoin in the way that Satoshi Nakamoto described in the white paper, and it remains a digital commodity because accountability remains with the users because the signatures are on the transactions. And I mean, this is absolutely key to Craig's identity as Satoshi Nakamoto. But I'm suggesting the lawyers didn't understand this, which is why they weren't able to question him about it. But that is the crux of the matter. Every single other implementation, of a shitcoin, an alternative protocol, is fraud. It is securities fraud because data can only be commoditized one way, with accountability moving from those who economically sustain the network onto the users through the chain of digital signatures. Once the chain of digital signatures is broken, accountability is lost forever. That is it. There is no going back once that chain of signatures is broken because accountability is lost. You cannot go right back to the start of the network because the chain of signatures has been broken. I literally cannot stress this enough. So they should have said that. Put that to Adam Back. Right, so the only way it can scale is by committing fraud. Right, so the only way you can actually scale Bitcoin and not committing fraud is the way that Craig has done, and Craig is claiming to be Satoshi Nakamoto, and no one else can scale it in the way that he has scaled it. That's it, because he created it. It's a fundamental argument that was missed out of this court case, which really pisses me off. But yeah, the court case is superfluous to Bitcoin's economic model. All it is just literally there for Craig's own safety and security, because Bitcoin had to go through a period of neutral organic growth where his identity had to remain a mystery and hidden for long enough for the network to grow neutral and organically. And people keep saying, oh, Craig has claimed to be Satoshi Nakamoto since 2016. What they conveniently leave out is that he was pointed, had the finger pointed to him by Gizmodo and Wired Magazine, who created articles saying, here is all the evidence that you need that Craig is Satoshi Nakamoto in 2015. They always conveniently leave that out, which is pretty ridiculous. So let's go back to the law here. So again, we saw the court and all that. There was no jury in there. And it was also in the High Court of England. And just to remind everybody what Halsbury's Law is, Halsbury's Law of England is the authoritative source on the laws of England and Wales. Halsbury's Law of England and Wales is the only comprehensive narrative statement of the law of England and Wales, containing law derived from every source. And it says here, clear as day, administrative courts are unlawful. And let's go back to this first sentence here. Halsbury's Law states, the law is absolutely clear on this subject. There is no authority for administrative courts in this country and no act can be passed to legitimise them. So the High Court that we're in here was purely an administrative court with no authority. The judge is just pretending to be a judge and voicing his opinion. It's absolutely outrageous. And then we go to the presumptions of court. So let's have a look at point 2 here. I mean, this is outrageous. The presumption of public service is that all members of the private bar guild, which all judges are, who have sworn a solemn, secret, absolute oath to their guild, then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked, and James Miller was not, and rejected, the claim stands that these private guild members are legitimate public servants and therefore trustees under public oath. And the presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remained bound by that oath and therefore bound to serve honestly, impartially and fairly as dictated by the oath. Unless openly challenged, of which he wasn't, and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. And this is what's happened. So for those who don't know, there is a third part without a jury trial to actually to cast judgment. The judge is purely a third party in this business transaction. And the judge's oath is purely to protect the financial system of the City of London. That is it. Now, Craig, being Satoshi Nakamoto and having created Bitcoin, which is a disruptive technology, it means that the judge is always going to rule against him because it is contrary to the financial interests of the bank who are perpetrating securities fraud on everybody. There is no way that the judge was ever going to rule in Craig's favour because he's not impartial. He's ruling on behalf of the banks and saying, we don't really want this. So literally all he's got to do is stand there and go, exactly what he did. He was given his orders. Craig is not Satoshi Nakamoto. He did not write the white paper. He did not start the network. Blah, 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 blah. So that's literally all that's happened. Nuts when you realise it. So anyway, that's my rant over with. So let's have a look at the price here. So BTC versus Bitcoin. Bitcoin going down, in price comparatively. But really, as I keep telling people, Bitcoin is an economic model. And look at this. So BTC has come down from 73 and it's now $67,000. Well, what's going on there? Surely, Craig being found to not be Satoshi Nakamoto, you'd think the price would carry on going up even more. But it looks to me like Tether was pumping the price purely to distract people away from the court case and having any speculation or doubts about Craig being Satoshi Nakamoto. That's all they've done. But really, Bitcoin is an economic model. So what you want to look at here is the profitability ratio. That's the most important fundamental thing. And check this out. So BSV is literally only at $90. I mean, literally $90. I mean, it's so low right now. It's crazy. But BTC is at $67,000 and the profitability is already in the red. It's already minus. So literally, as the price of BTC starts to fall, because there is literally no use case for it whatsoever. It is a Ponzi scheme. It does nothing. It can't do anything because of the 1 megabyte block size and the fact that it's got no contractual credibility or economic value because the signatures have been segregated from the transactions. It's absolute bollocks. So their price, literally like at an all-time high, being already in the red as the price comes down, literally, the profitability of the genuine Bitcoin just simply goes up and up and up and up. And the price literally is only at $90. So like when the miners are just like, hold on a minute, why are we mining BSV? Because it's more profitable, and it's profitable because people are using it. And if more and more people start using it, because the supply is fixed, the price is going to go up. What are we holding this BTC shitcoin for? Oh shit! And then obviously the market comes racing across. And as we see here, look at this. So we've got the block reward halving in 35 days. Just 35 days. So literally the block reward, which is what the miners rely on, is going to get cut in half. In half. Where are they going to go? They have to be able to cover their running costs. And the most valuable network is going to be the most useful network. It's the one that everyone uses. If no one's using it, what value is it? If something is useful, it's valuable. If something is useless, it's worthless. And let's have a look at Terranode. Check this out. Holy jeepers, holy moly. Look, we've got a 107 gigabyte block here. What's big? 121, 124, 130. That's the biggest one so far in this column. So we've got a 130 gigabyte block, and this is TPS, transactions per second. What was that, 130 gigabyte block? There we go, look. So that means there are actually large data sizes in that one. But I mean, look at this, average transactions per second, look, 1 million. What is significant about this is that there is no other digital network on Earth that can process more than 50,000 transactions per second due to the problems of the horizontal scaling problem and the replicating of software. There is no other digital network on Earth that can do this. Terranode, which is the testnet that we're looking at right here, is the only one that can actually do this. This is absolutely massive. And imagine you've got a 130 gigabyte block on the network. And the fees that come with this. The mining profitability is going to go absolutely through the roof, and BTC has got absolutely nowhere to go. It's already in the red, and the price is at all-time high, and it does nothing. What's gonna happen? You just use your common sense. This is what I'm saying. The court case is superfluous to requirements. The only purpose it's served is for Craig's own personal safety. Because when the market does see this and it flips, well, it's just like, well, I'm Satoshi Nakamoto. What's your problem? Whereas now they're just like, you've created this alternative system and the block fee is coming over and all the miners have gone over and I've lost billions of dollars. It's your fault. And we all know that these BTC douchebags, are literally, you can't explain anything to them. They haven't got the intellectual capacity to understand this, but all of us in Bitcoin have. So there we go. Anyway, that is a 28-minute show. Don't want to keep it too long. We'll leave it there. I hope you enjoyed it. As ever, be aware, take care, stay safe out there, and we'll see you in the next one.